Okay, thank you, sir. Creativity is seeing what others see and thinking what no one else ever thought. With these golden words of Albert Einstein, I, Vanshika Rastogi, Assistant Professor, Department of Artificial Intelligence and Data Science, East Point College of Engineering and Technology, welcomes you all to the Impact Lecture Series, Session 2, sponsored by MIC AICTE. Before starting the session on the topic IPR, a key attribute for startups, we would like to remember our beloved founder and chairman, Dr. S.M. Venkatapati. We would like to welcome our respectable chairperson, Srimati B.L. Ramadevi Venkatapati, in her absentia. My hearty welcome to our CEO, Sri Pramod Gowda sir, and Sri Rajiv Gowda sir, in their absentia. I would like to welcome our Executive Director, Dr. Shankar Palisar, in his absentia. I would like to welcome our beloved Principal, Dr. T.K. Satish sir, and I welcome all the HODs of various departments, faculty members, and students. Now, I request our Principal Sir, Dr. T.K. Satish, to share a few words with us.
Very good afternoon, everybody, and Ma'am Girija Madam, thank you very much for accepting our invitation and to be the guest for our impact series of lectures. See, I think the
Pleasure is
major
mine.
particular thing that we as entrepreneurs we had to be looking at the particulars of is that what are all the patents that essentially we may be floating it across? What are the copyrights that essentially will be able to do that out? Because if you look at that particular front recently, for example, if you look into that, even in USA, there was a copyright particular front with regard to a simple scrub particular this. So the thing is that how essentially, in fact, they are, if everybody, for example, the color and the combinations of the particular this or how essentially it appears, that all that is copyrighted. So the thing is that either it can be a design patent or it can be a manufacturing patent or various other particular will come into the picture. So these particular attributes becomes very important for a startup particular this. Before we start any particular, we need to be able to understand these particular stuff and then be able to say that am I essentially floating any rules and regulations, because otherwise that becomes a bigger problem to tackle more than the business particular this. So in that particular sense, we are lucky to have Girija Madam with us, who essentially is a champion in this particular field. Madam, we look forward to you to hear and then listen and then to learn from you. Thank you very much and all, and then happy listening. Thank you.
Thank you so much, sir. Now, I would like to call upon Ms. Megha Menon, Assistant Professor, Department of CSE, to introduce our speaker for the day.
Thank you, ma'am. Good afternoon to one and all present here. Girija, founder of IPaatEntiti IP, is a across worldwide range of domains in science and technology. She focuses on handling issues related to patent, trademark, copyright, design, including searching, drafting, prosecution, licensing, monetization, and counseling clients on addressing IP management and formulating IP strategies. She is also a trademark attorney and an advocate. Additionally, she is a seasoned speaker and talks about the intellectual property related matters at various conferences, academic and research institutions, and corporates. Girija has a master's degree in science and holds PG diploma in IPR law, bioinformatics, technology management, and business administration. She is an expert panel member of the WTO and Relay Cell of Visheshwaraya Trade Promotion Center, Government of Karnataka. She is empaneled as a patent agent for various institutes and colleges. She is also a facilitator for startups in patent, Government of India. Welcome, Nuna.
Thank you. Thank you very much for the warm introduction.
Thank you, Megha ma'am. With the brief introduction of our eminent speaker for the day, I would like to now welcome our speaker to please take over for the session. Thank you so much, ma'am.
Yeah, thank you. Good afternoon, everyone. It's a pleasure to get connected with you all through this webinar. And in this session on IPR, a key attribute for startups, I will start with the overview of IPR and then move to patents, designs, and copyrights. The three important IPRs related, which are highly relevant to the domain of engineering. And then I will end up with the IP management for startups. Overview of intellectual property rights. Generally, I call this session as a warm-up session because IPR is no more an uncommon phrase in India. You would have heard or read about IPR through different modes of media. So, what is IP? See, IP is used to describe the results of creative and innovative endeavors. See, we call it as intellectual because it is created by the intellect of the human mind, and we call it as property because like the tangible property, this intangible property can also be owned, sold, leased, or transferred. What are the ways of protecting IP? So, innovative products and processes can be protected through patents. Brands can be registered under trademarks. Literary, artistic, musical, photography, they can be protected under copyrights. Creative designs and industrial designs, indication of origin and the geographical indication, and any confidential information can be kept as a trade secret, and the layout design can be protected under Semiconductor Integrated Circuit Layout Design Act. A single product can be protected by many IP rights. I have taken the pen as an example. See, the pen as a product can be protected through patent. The name of the pen you can register under the trademark. The composition of the ink, which you do not want to reveal to the others, you can keep it as a trade secret. The style of the writing can be protected under copyright. The look and the feel of the pen can be protected under industrial design. First, we'll see what's a patent. So the patent, it's a legal document which will describe an invention and creates a situation in which the invention can be exploited only by the authorization of the patent owner. So we'll see in detail about the patents in the later part of our session. Trademark. This is again an important IPR. What's a trademark? It's a sign that distinguishes the goods or the services of one person from those of the other. So it can be a word, a letter, a logo, or a number, shape, smell, color, etc. So Yogo Odal is one of such sound trademark which is protected in India. There are four types of trademark: the certification mark, service mark, collective, and trade dress. So certification mark is generally used to certify the goods. So I have given an example of ISO 9001. Service mark is generally used in services industries like bank, insurance, airlines, etc. And collective mark is owned by organization like Lions or Rotary Club. And trade dress generally refers to the total package of the goods. Trade secret. This is the third important IPR facet. Trade secret is any confidential business information that provides an enterprise with a competitive edge. So I have given a few examples. The famous Coca-Cola formula, data compilations, manuals, and financial information. So the main important characteristic of trade secret is that it can be protected without registration for an unlimited period of time. What are the elements of trade secret? See, it should have an economic or commercial value. It should generally be not known to the others, and reasonable measures should have been taken by the holder to maintain secrecy in the form of non-disclosure agreement. The other IPR, GA. GA is a sign used on the goods that have a specific geographical origin, and it possesses qualities, reputation, or characteristic that are essentially attributable to that place of origin. Approximately there are 417 GA registered in India. I just given a few examples taking from all the directions of our country. So you can see Darjeeling tea, Kullu shawls, Dharwad peda, Nashik valley wine. So these are some of the GAs of India. Copyright. So the copyright protects the creative works of the authors, such as writers, artists, architects, photographers, directors, and music composers. What are the types of work that can be protected by copyright? Literary, musical, artistic work, maps and technical drawings, photos, motion pictures, computer programs as such, and multimedia products. Copyright protects only the expression of the ideas. See, abstract ideas cannot be protected. So you have to express your ideas on the tangible forms. And the copyright owner has the exclusive rights to reproduce, adapt, translate, distribute, publicly communicate, and publicly perform. The related rights to the copyrights are the performer's rights and the broadcaster's right. So, what is performer's right? See, if a TV channel wants to broadcast a live telecast of a dance, then he should get the permission from the dancer. The broadcaster's right. See, no person can make a visual or audio recording of a broadcast without the permission of the broadcaster. The industrial design, this is another important IPR for engineering. See, in industrial designs protects the aesthetic designs that are applied to the articles. So it can be a shape or a pattern or an ornamentation or any other artistic aspect. And designs which have functional value are not protected under industrial designs. So I've given in the shape of a car. See, if the shape of the car increases the fuel efficiency, then it cannot be protected under industrial designs. You have to go for patent. The other IPR, Semiconductor Integrated Circuit Layout Design Act. This is one of the IPR which have been less explored by the people. And this Layout Design Act, it is covered under the Semiconductor Integrated Circuit Layout Design Act. So layout design means the arrangement of the transistors and other circuitry elements in a semiconductor integrated circuit. So what are the criteria to register a layout design? It should be original. Original means it should not be a copied one, and distinctive, it should be distinguishable from the existing designs, and it should not have been commercially exploited anywhere in India or any in convention country, means the countries which are parties to the Paris Convention. What is the term for protection of SICLD is 10 years from the date of filing of the application. Having seen the term of protection for SICLD, we can also see the term of protection for the important IPRs. So patent, the term of protection is 20 years, but every year you have to renew it. Trademark and GI, it's perpetual, but every 10 years you have to renew it. Copyright is the human life plus the 60 years. There is no need to renew the copyright. And design, the term of protection is 15 years. So initially it will be granted for 10 years. So on the expiration of the 10th year, you have to apply to renew it for the next 5 years. And this is a trend and filing of IPR applications in India over 5 years. And this is the latest data available from our IP India website. And you can see nearly some 4.25 lakh applications have been filed, out of which trademark occupies the first position, followed by the patent and the copyright. This is the latest information. Like I think in March, it was notified in the IP India website. So they say that in the first time in 11 years, the number of domestic patent filing is more than the international patent filing. And again, the filing patent has increased by 50%. They have just taken the last 5 years. And they also say the information says that there is a 5-fold increase in the grant of the patent. And there is a reduction in the time of the patent examination from 72 to 23 months. It's a pleasure to share with me also, like we got 2 patents granted and 1 patent is also going to be granted very soon. In 6.5 months, we got it granted because we went for the fast track mode as the applicant was a startup. And and you can see because of this, the India has moved from the 81st position to the 46th position. So there is so much positivity in the IPR atmosphere. And so it is time for us to translate our products into the IPR rights. So I'll now move to the second part of our session, the very important part, patenting procedure. We'll walk through a short introduction and then to the patentable and non-patentable subject matter, contents of patent specification, and patent filing mechanism. What is a patent? As I shared earlier, it's a legal document which describes an invention. But at the same time, it creates a legal situation in which the invention can be exploited only with the authorization of the patent owner. Patent protects an invention and it grants exclusive right to the inventors for a limited period of time. As I told you that the patent protection is only for 20 years from the date of filing of the first application. After that, the patent will come to the public domain. Why do I go for a patent? To protect my invention, to enjoy the exclusive right, and to ensure commercial return. Is patent necessary? My answer will be a big yes. To encourage research and development and to stimulate the capital investment which leads to the growth of economy of the country, and to also to encourage establishment of new industries, patent is highly necessary. Patentable and non-patentable subject matter. This is an important part in the patent. See, what can be patented? The first one. The invention must be novel and it should involve an inventive step and it should be capable of industrial application. It should not fall under Section 3 and 4 of the Indian Patent Act. What is novelty? Novelty is the invention should not be in the public domain. Prior use and prior publication or the obstacles for granting patent. That's why we always advise our clients that first file and then publish. And again, the invention need not be itself new. Like the invention need not be a breakthrough invention. Even a small improvement or over the product or the process is also patentable. Inventive step. Inventive step is the adequate technical advancement. That technical advancement should not be a workshop variation. See, what I mean by workshop improvement or workshop variation is that, see, when you develop a new product or a process, routine improvements will happen. See, these routine improvements are referred to as the workshop improvement, and these are all not patentable. And the third one is the industrial application, which we call it as the utility or the usefulness. So any invention should be capable of being made or used in any kind of industry, whether or not for the profit. Having seen what is patented, we can now see what are not patentable in India. So Section 3 and 4 of the Indian Patent Act, they have just listed down what are not patentable. The first one is the frivolous invention and the inventions contrary to the well-established natural laws. So I have given the example for frivolous, like making in one piece the articles which already existed in two or more pieces. And the perpetual machine, which is contrary to the natural physics. So these are all examples for the frivolous invention and inventions contrary to the well-established natural laws. And inventions contrary to the public order or the morality. So gambling machine is not patentable. It's against the public order. And device for house breaking, biological warfare material. So these are all examples for inventions contrary to the public order or morality. Again, a mere discovery of a scientific principle, a formulation of an abstract theory, or a discovery of any living or non-living substances occurring in the nature or not patentable. So if you discover a microorganism, it is not patentable. But if you genetically modify it, it is patentable. Again, Newton's law, these are all not patentable. Mere discovery of a new form or a new property or a new use of a known process or a machine or an apparatus is not patentable. See, I have given an example like a crystalline form of a substance. See, already the amorphous form exists in the public domain and you have come with a crystalline form. This is a new form of a substance. So it is not patentable. Again, a new use of an aspirin. Aspirin, it's well known, like you take it for a headache. Now you say it is also ails the heart. Then again, it's a new property of a product. So it is not patentable. And substances obtained by mere admixture. It's like you mix two drugs like paracetamol, brufen, and you come with a drug. It is not patentable. So whenever you try to submit a patent application which is related to a composition or a formulation, see, which consists of many components, we should provide the synergistic data. Synergistic data is nothing but the interaction between the components in the composition or a formulation that you have to establish that data. Only if that data is provided, the patent will be granted. What again, the mere arrangement or the rearrangement or the duplication of the known devices, each functioning independently. I given like this is mostly related to mechanical patents. So I can give just a simple example. I've given a clock and a radio is in a single cabinet, an umbrella with a fan. A method of agriculture or horticulture is not patentable. So any type of method which is done in the open field is not patentable. A method of treatment of human being or animals to render them free of disease or to increase their economic value. So if you perform an art surgery, it is not patentable, but if you do a cosmetic surgery, it is patentable. Plants and animals are not patentable in India. Again, essentially biological process, and also seeds, varieties, and species. As I said, microorganism, genetically modified microorganism is an exception. Mathematical, business method, computer program as such, the algorithms, these are all not patentable. So for a computer program as such, algorithms, you can go for copyright. But the computer program as such is not patentable. But if it is embedded in hardware or it produces a technical effect, it is patentable. So I just give an example, like a computer program for word processing is not patentable. But if it is embedded in a phone and it transfers the message from one cell to the another cell phone, then it is patentable. Literary, dramatic, musical work, or any creative works. See, these are all copyrightable and it is not patentable. And method of performing a mental act or a method of playing games is also not patentable. A presentation of an information. So example is that if the information is expressed through a different visual display or a symbol, or if you use some diagram and then explain it, a novel diagram also, it is not patentable. Traditional knowledge. Suppose you say that the turmeric heal wounds, it is not patentable. But if you come with an ointment curing some with that, along with the turmeric, you use some excipients also, then it is patentable. This invention relating to atomic energy comes under Section 4 of our Patent Act. So no patent will be granted, which is for an invention which is related to an atomic energy, and it falls within the Section 21 of the Atomic Energy Act. And this is the crux of what I have been talking. And this is the filter model developed by Dr. Kalyan of Banana IP. And you can see that there is an invention at the top, and you want to get the patent. Then it has to pass through these 5 folders. So what are the 5 folders is that? First one, as I said, subject matter. The subject matter is that it should be a patentable subject matter. So it should not fall under Section 3 and 4 of our Act. Then usefulness is that utility. So it should have the industrial application. Novelty is newness. See, prior use and prior publication are obstacles to novelty. Non-obviousness is the technical advancement. You should show the technical advancement. Adequate technical advancement should be there, and it should not be a mere workshop variation. And specification. Specification is the legal document which we submit to the patent office. And we'll see in detail about that. Patent specification, it's a techno-legal document. The scientific details of the inventions are mentioned in the specification. And generally, we call this patenting activity as a quid pro quo act. That is something for something, because the inventors will disclose the invention to the government. In turn, the government grants the exclusive right to the inventors, so which prevents the use of the invention by the others. There are 2 types of specification: provisional and complete. So provisional specification is normally filed when the invention is at the conceptual stage, and you know that you need time to work on it. So at that time you can file the provisional specification, because once you file provisional, you will have 12 months time to file the complete specification. So you can use that 12 months time to work on the invention and provide the complete details of it. But no patent will be granted based on the provisional specification, and you have to file the complete within 12 months. If you don't file, then it will get abandoned. But if the invention is at the first instant itself, it is you have all the details of it, then you can directly go and file the complete specification. Patent has 3 main sections: cover page, specification, and claims. So cover page will present the bibliographic invention, and claims define the scope of the invention for which the protection is claimed. And this is the cover page. See, as I said, it gives about the bibliographic information. You can see the application number, date of filing, the title, what is the classification of it, who is the applicant, and a short abstract. And specification, it has the following columns: title, field of invention, to which field it is related to, a broad one we have to give, and background of the invention, objectives you have to provide, the summary of the invention, detailed description of the invention. If your invention has drawings, you should also briefly describe inside the specification, and along with that you have to attach separately the drawing sheets and then short abstract. Claims. The claims are the important part of a patent application because it defines the scope of the protection, and it should be drafted carefully to cover all the aspects of the protection. And we always say that drafting of claim is an art and a science, and there should be at least one claim in a patent application. And what is not claimed is disclaimed, and it is open to the public use. Move to the patent filing mechanism. So who can apply for a patent? Either alone or jointly. Say a true and first inventor can apply, or an assignee can apply, or a legal representative can apply if the inventor or the assignee is deceased. Where to file it? See, in one of the patent offices based on the territorial jurisdiction of the place of the office or residence of the applicant or the agent. So the south states, we have to file in Chennai. So there are 4 patent offices, one in Chennai, Mumbai, Delhi and Kolkata. So the southern states, they will file in Chennai, and the western in Mumbai, northern in New Delhi, and the rest of the states in Kolkata. How to file a patent application? Either through online or post or by hand submission. And now more than 90%, 95% it is done through online, and they do accept it through post also in rare cases. And hand submission, it was taken away during COVID. I do not know whether they have revived it again or not. And this is a general procedure for obtaining a patent. First, file a patent application, and then you have to wait for 18 months to get it published. And there can be a pre-grant opposition, which can be represented by any person. And if you after filing RFE, which we call it as a request for examination, your patent application will be taken up for examination, and it will be granted or refused. See, once it is granted, again it will be published in the Indian Patent Journal. And there can be a post-grant opposition, which has to be filed within 12 months from the grant of the patent, and controller's decision is final whether to revoke or not the patent. What are the documents that have to be filed for a patent application? So these are the very basic documents. So application form, which we call it as form 1. And as I said, your invention is completed. The first instant, go for complete specification. If you want to work on it, you file. If it is in the conceptual stage and you don't have the full details of it, you can go for provisional. So the application form should be accompanied with form 2. That is, it can be either provisional or complete. And you should also give an undertaking. If you file in outside India, you have to inform patent office, and the declaration by the inventors along with the required fees. So this is the fee. You can see natural person is the individual, small entity, startup, and educational institution. The fee is only 1,600. So for educational institution, recently last September, they have reduced the fee by 80%. It was 8,000. They have reduced it by 80%. So it is now only 1,600 for educational institution. So others like includes private and public companies, research institutes, they all come under others. So this is subjected to 30 pages of the specification and 10 claims. So if it is more than that, you have to pay the extra money. So we'll move to the third part of our session, industrial designs. See, generally in India, we do not call designs as design patents, but synonymously it can be used. And we have to protect our designs under the Industrial Designs Act. So what is a design? As I said earlier, it refers to the features of the shape or a configuration or a pattern or an ornamentation or a composition of the lines or the colors, which is applied to any article produced by the industrial process in which the finished article appeals to and judged solely by the eye. What are the essential requirements for design registration? The first one is that it should be original. Original in the sense it should not have been a copied one, and it should not have been disclosed in the public. Third is that it should be distinct, that is distinguishable from the existing designs. Again, it should be applied to an article and should appeal to the eye. It should not comprise or contain scandalous or obscene matter, and it should not be contrary to the public order or morality, and not be prejudicial to the security of India. What are excluded from the scope of the design? A book or a calendar, certificates, labels, cartoons, these are all excluded. And again, any mechanical principle or a construction of an article, buildings, structures, these are all not protected under the designs. And even a part of the articles which are manufactured and sold separately. And then variations which are like we say the workshop variations or the workshop alterations, these are all not protected under the design. And mere change in the size of an article, so change in the shape of an article is protected, but change in the size of an article is not protected. And flags, emblems, signs of any country, and layout designs of IC, I said like layout designs of IC is you have a separate act, and so it is not protected under the Industrial Designs Act. Who can apply for a design registration? See, any person or the legal representative or the assignee, they can apply. So the person, it includes an individual or a firm or a partnership or a small entity or a body corporate. So you can get your design register in just 10 steps. So what is the first step? See, you have to see whether your design already exists in the public domain, whether it is registered already. So this you can see it through the databases which is available in the public domain, or even you can write to the design office and then you can find it out. Then prepare the representation of the design. This you have to give different views of your design, like a top view, bottom view, a perspective view. So these are all the different views of a design you have to prepare. Then identify the class of the design. So there are 32 classes in the Locarno classification. So you have to identify the class to which your design belongs. Then provide the statement of novelty. So novelty is that you should say where does the novelty lies, whether it is in the shape of the design of your product, or in the design it occurs, or in the configuration. So you have to provide a statement of it. Then include a disclaimer. So when your design has some trademark or some mechanical principle, you should include a disclaimer that you don't claim for it. And then claiming a priority date. See, this normally is applicable to the people who has registered, who has applied outside India, and then they also come to apply in India. So at that time, they can claim the priority date. Priority date is the first filing date. Then determine what is the fee to be paid. So in India, the design fee is 1,000 rupees, 1,000 for individuals and 4,000 for others. And see that all enclosures are attached. See, if suppose you go through a patent attorney, so you have to provide power of attorney that has to be enclosed. This is one important document. And complying with objections, if any. See, you after sending the application, immediately if there is any minor objection, it will be returned to us. So comply to it immediately. See, this can be done if you provide all the details, like the correspondent details, everything in complete way. This will enable the design registration to speed it up. Again, where to file the design? See, again, it can be filed in any one of the patent offices, Delhi, Mumbai, Chennai, or Kolkata. But the prosecution of the design application is done only by the Patent Office, Kolkata. What are the benefits of design registration? So the design registration, why we have to register a design? That's a question. So you get an exclusive right over the design of an article. And again, when there is an infringement, only this document is produced in the court. And while you want to commercialize it, either you want to license it or you want to assign it as a legal property for a royalty, then this document is very important. As I said, the official fee for filing a new design application is 1,000 for individual, startup and small enterprise, and 4,000 for others. And I'll just share the few examples in the domain of engineering where the designs have been registered. So you can see these are all the new designs of an antenna. And again, these are all some of the parts related to the computer science. They have come up with a laptop, and then you can see the monitor. So these are all some of the new designs in the field of computer science. And again, vehicle. See a bike or a motor vehicle. So these are all electric vehicle. They have registered under the class 12. They have registered cycles and motorcycles. And even if you see the electrical engineering, even a socket, yeah, the socket, the electrical connector, these are all registered under the Industrial Designs Act. And even smart bins, they have also the new designs of the smart bins. And even COVID accessories, they have also found a place in design registration. Okay, we'll move to the fourth part, the copyright. As I said, patent is for intellect works and copyright is for creative works. What are the important characteristics of the copyright? See, copyright is not a common law right. So it is created under Copyright Act 1957. And copyright means it has multiple rights, like a right to reproduce, a right to translate, right to adapt, a right to publicly communicate. So these are some of the rights the copyright gives to the holder. And the work must be original. That is very important. It should not have been a copied one. And again, abstract ideas are not copyrightable. You have to express it in a tangible form. What are the works that can be protected by copyright? Original, literary, dramatic, musical, and artistic works. And the computer source code, they comes under the literary work, so you can go for protection for copyright. And cinematographic films and sound recordings. What cannot be copyrighted in India? Ideas, methods, and systems. I have just given few examples: scientific or technical method or discoveries, business operations, procedures, mathematical principles, or formulae. How to register a work under copyright? Just visit this website, copyright.gov.in, and if you're a new user, so provide your make your user ID and password. Then go to this copyright registration form, click it. So first fill form 14. Then you should also upload the signature of the applicant. Fill the statement of particulars. Then fill the statement of further particulars, and then make the payment. So once you make the payment, you will immediately get a diary number. So here in copyright, we call it a diary number. In patent and all trademark, you will have that application number. And artistic work should be uploaded in this format if it is an artistic work, and if it is a literary or dramatic work, you have to upload in PDF format. And once you do this online, you should also send the hard copies of few documents to the Copyright Office, which is in Delhi. And these are the official fee for the copyright. If it is a literary, or you want to go for a computer code, or dramatic or musical or artistic, the fee is only 500 rupees. And if it is a cinematographic film or a sound recording, it is 5,000 and 2,000 respectively. What are the advantages of copyright registration? As I said, for design, it provides exclusive right, or it provides a ownership for you to claim authority. And in case of infringement, this is the document which can be produced before the court, and to claim the statutory damages. This is very much important. And in case of commercialization, if you want to license it or if you want to assign it, this document is very much important. And this is the flow chart of copyright registration. So first file the application, then you will get the diary number. And once you file, your application will be in a 30 days mandatory waiting period. why they keep like this is that they see that whether there is an opposition filed by any party. See, if there is an opposition, then it will go this channel. If there is no opposition filed by any party, then your application will be scrutinized by the examiner. And if there is no any discrepancy, that is, there is no differences, then it will go to the registration. So we have got some 4 or 5 copyrights, more than 5, I think. So they have gone through this path. There was no opposition, there was no discrepancy, and even one we got it in a record period of 32 days, which because after 30, immediately 2 days we got the copyright registered. And if there is objection, then the registrar will call both the parties, and then they see it whether to accept it or not. So if they accept, again this will go through this channel. It will be examined, and then it will go for registration. If it is not accepted, it will be go to the rejection part. We'll move to the last part of our session, IP management for startups. See, in the words of Mark Getty, intellectual property is the oil of the 21st century. So you can see currently startup is the global trend, and even Government of India has taken many initiatives to promote this culture. See, when you come to the IPR, many amendments have been made, especially in the patent rules. For example, as I said that there is an 80% reduction for startups. The application fee is only 1,600. And again, they are one of the applicants who are eligible to go for fast track mode, so that they can get the patent very fast. See, I said during my earlier part of the session that 2 patents we got granted in 6.5 months. So that is one thing. And the third thing which I want to share is that there are many schemes available, either in the state level or in the central level, that they give back your money which you spend on the patenting process if the applicant is a startup. Reimbursement is there. So we have to, it's high time that the startups culture is promoted. At the same time, the IPR culture is also promoted. So the strategic management of IP is necessary because it enhances the startup success by 3 ways, like by establishing a market advantage is there, and it also improves the financial performance, and there is an overall enhancement in the competitiveness of the startup over the others. And 4 types of economic value can be derived by the startups from IPRs. So the first one is the practicing. So what I mean by practicing is that, see, you have come with a new product and you have patented it, and you yourself start manufacturing it. So that is called practicing. So then when you do that one, it leads to the higher market share, higher sale price, and in turn to the higher profit margin. So that is the first one. And if you do not practice it, you can go for the licensing or assigning. So you can commercialize it either by licensing it or by selling your patented product, and thereby you can earn the royalty. And the third one is the IP as collateral. As I said, that IP is an intangible product, so it is an intangible asset, so you can use it as a financial instrument. The fourth one is the litigation. So in litigation, you can earn money, or it gives an economic value either by settlement or court award damages. And the fifth type of thing where you can earn economic value is the deterring. Deterring is normally we call it as defensive patenting, and it is opposite to the litigation. So what people will do is they will file a counter patent to the patent under litigation. So this will improve the freedom to operate of the patent firm who is either practicing or who have taken the license of the product. But the main driver of effective IP management should always be the creation of the value in line with your business strategy. So that is the core of the slide, this one. And this IP management strategy is a team sport. So there should be equal play from the research and development, the legal, and the management department. Finally, I would like to wind up my session, leaving this thought to you. Thank you, one and all, for giving me this opportunity.
Any queries to anyone? Ma'am, I myself has a query.
Yeah, please.
Actually, like if we have we have published a patent, so after how much duration can we go for the grant for that particular patent?
No, that is left to the patent office. Once it is published, if you have filed the RFE, that is request for examination, your application will be taken up by for examination by the patent examiner, and then FER, first examination report, will reach you, where you have to respond to it within 6 months,
Okay,
and
so
there
we have
can
a
be a
duration of six
hearing.
months.
No, not duration of 6 months. See, that I am telling only after the issue of the first examination report. See, once it is published, I think this process is speed up now. Very okay. So it depends upon the examiner or the controller who takes up your application. So once they examine it, you will get the first examination report. For that, you have to respond within 6 months, and
Okay.
there can be 1 or 2 hearing or no hearing also to grant your patent. See, it has
Thank you so
reduced a
much,
lot
ma'am.
now. We have got patents, like if we go in the fast track mode, I said like we got patents in 6.5 months. And other patents also, we have got it in 2 years to 2.5 years. We have got many patents granted.
Thank you, ma'am. Thank you so much, ma'am,
Thank
for
you.
such an informative session. Now
Thank
I
you very much.
request Professor Ravi Kumar, Associate Professor, Department of Computer Science and Engineering, for the vote of thanks.
Yeah, thank you, ma'am. Yeah, thank you, ma'am. A very good afternoon to all. I reckon it a great honor and privilege to propose a vote of thanks on this memorable occasion. Today, I take this opportunity to express my gratitude and appreciation to all those who made this event such a resonant success. To begin on behalf of East Point College of Engineering and Technology, Bengaluru, I would like to thank our resource person for the day, Mrs. GIRIJA Madam, IPR attorney, founder, IPaatEntiti, who spared time from her busiest schedule to grace this occasion. Thank you, ma'am. My heartfelt thanks to MIC, AICT, Government of India for helping us in sponsoring and organizing this event. My heartfelt thanks to all the students who attended this event and made a grand success. At last but not the least, I would like to thank all the faculties for their support and cooperation in organizing this event. Thank you, one and all.